Violence against Native women is astronomical.
84.3% of all Native American women have experienced physical violence. 55% of Native American women have been raped. And those statistics make us the highest demographic for physical and sexual violence. 1 in 3 families either has someone that's missing or murdered or has been sexually assaulted.
Our story, historical story, is really important to understand. What tribes are learning and dealing with today is how is it that we heal that historical trauma.
The tribes recognize, at least this community does, that domestic violence as well as substance abuse is unfortunately generational. Many parents have seen or been victimized and are survivors. At some point though, either as a parent or as a child, that difficult decision has to be made to step in, get the help necessary, whether that be involving the court system or counselors to try and break that cycle. I'm now seeing third generations where that step hasn't been taken to try and break that cycle of violence. We don't have the immediate guaranteed fix, but at least we can keep people safer if they take that step and engage and access the services that are available to them, and hopefully make things better for their children and or improve the relationship they have with their parents who might not have had that opportunity.
When you look at how trauma is handed down, my mom stayed in an abusive relationship for 42 years. And even though I stayed for 4, it's less than my mom's 42. So I have to realize that that's a win. And I have to hope that doing this helps my daughter so that she recognizes it early on and doesn't stay for any of it. And that the changes can be made so that women do recognize it. They don't stay trying to find ways out, because finding ways out is too hard at this point in time. Things had escalated to the point of my life wasn't safe. My family's life wasn't safe. Because once you make that decision to actually get out, there's no turning back. And once you make that decision to ask for that PPO, I've seen women ask for it and not get it, and then they don't have their life anymore either.
Personal protection orders, without a doubt, save lives. They prevent people from being violent, potentially fatally violent, with ex-spouses, ex-boyfriends, ex-girlfriends. I think they also change lives. The law is clear that tribal PPOs can and should be enforced in the same way as other protection orders.
So the easiest way to think of tribes in the state of Michigan is they're each their own country who has entered into agreements with the federal government as well as state governments so that when orders come out of a tribal court, they are no different than a state court order.
This isn't an optional thing, it's a requirement. The police, the prosecutors, the courts must enforce personal protection orders issued by tribal courts.
We know for a fact that domestic violence escalates. We know that if not dealt with and handled early on, the harm and the assaults tend to escalate up to and including someone could lose their life.
Personal protection orders allows that person to perhaps end an abusive relationship in a way that they feel confident they will be safe. They need to feel like the court, the police, is going to protect them in doing what might be one of the most difficult things they have ever done in their life.
It's extremely crucial for tribal court orders, particularly personal protection orders, to be enforced off of tribal reservations, because violence against women, children, and men doesn't stop at a reservation border. Often victims are subject to violence and more victimization off reservation.
Whatever your political ideals of sovereignty of tribes are, that needs to be put aside, because we're talking about safety of people. We're talking about potential deaths, and that is something that can be preventable if these orders are enforced the way that they should be.
I think the barriers when it comes to enforcing tribal PPOs are not so much legal as procedural. The problem maybe comes in when officers don't understand the procedures. They don't understand where to submit the paperwork. They may not be familiar with the tribe, the people who work there, what sort of paperwork they require when someone violates a personal protection order. The good news is that the law gives them full authority to enforce the order just like any other order. If someone is violating, they should arrest them if they have probable cause to do so.
There really shouldn't be any confusion, because the law is very clear. The federal law gives us the authority to do this under the Violence Against Women Act 2013 and 2022-23.
The Violence Against Women Act was the first piece of national legislation addressing violence against women in the United States. And due to the advocacy of Native women, particularly a woman named Tilly Black Bear, it included protections for Native women, because violence against Native women is at an exceedingly high rate. But one of the things that they wanted to make sure was that the particular experiences of Native women were taken into consideration, because Native women face tribal jurisdiction as well as state and federal jurisdiction. And so one of the things that they wanted to do was to make sure that Native women are protected wherever they are. A lot of Native women live on reservation, but living on reservation doesn't mean that everything you do is on reservation, so that they might leave the tribal jurisdiction to go to the grocery store or take their kids to school or go to work. And so one of the things they wanted to do was make sure that women could get protection orders, because it's a way to stop continuing violence and kind of interrupt that cycle of violence. But they wanted to make sure that there was seamless administration of justice, so that if women left the reservation, they would be protected if their abuser tried to confront or attack them off the reservation. But the problem is that you have two different jurisdictions. You have tribal jurisdiction on reservation lands, and you have state jurisdiction off reservation lands. And so what they had incorporated into the Violence Against Women Act is a provision that gives full faith and credit to protection orders issued by a tribal, state, or territorial jurisdiction wherever the woman is. So the idea is that if a woman leaves the reservation and has a tribal protection order, it will be enforced by state law enforcement once she is off reservation lands. Similarly, what the provision does is it says that if you have a state protection order and you go on to tribal lands, that tribal law enforcement are supposed to recognize and enforce it as well. And so a part of our federal constitution is this idea of full faith and credit, because you can't have seamless administration of justice if you can get an order in one court and it doesn't get enforced by law enforcement or the courts of another jurisdiction. And so it comes from this older idea that's part of our Constitution that courts in the United States should give each other full faith and credit, and that means that they should honor and enforce each other's court orders and judgments and legislative acts across jurisdictional boundaries. And what the Violence Against Women Act did was it included in this concept of full faith and credit tribal governments as another set of sovereigns that deserved this same kind of respect.
The Violence Against Women's Act, I think, was a crucial piece of legislation. Number one, it allowed local law enforcement to enforce these tribal personal protection orders and keep a lot of people safe. If the victim is a tribal member on tribal land, they can enforce laws related to stalking, to domestic assault, to personal protection orders. It allows them more latitude and more authority and more power, and rightfully so, to protect their community within their community territory.
What the VAWA provision does is it gives the full force of federal law behind those tribal protection orders. So it's kind of like it supports tribal sovereignty and kind of reinforces it. One of the things under our Constitution is that we have a supremacy clause, and what the supremacy clause basically says is that if there's a conflict between state law and federal law prevails. Putting full faith and credit into the Violence Against Women Act and making it part of federal law gives it this kind of additional force in relation to the states. So if a state doesn't enforce a tribal protection order, basically that's a violation of federal law because the state doesn't have the authority to make that decision once the federal government has enacted the instruction in federal law for the state to do it.
This isn't an optional thing, it's a requirement. The police, the prosecutors, the courts must enforce personal protection orders issued by tribal courts. State court prosecutors, state law enforcement, sheriff's department, local police departments, if they see that someone is prohibited from doing something under a tribal protection order and this person is in violation of it, they must treat it like it was issued by a state court. They must treat it in the same way they would any other personal protection order. If this person is violating it, they're subject to immediate arrest.
Put yourself in that victim's shoes. What if there is no one out there that's going to help them? What if they have been victimized for so long? Domestic violence is very, very complicated.
Once you understand that, you can understand from a victim or a survivor's perspective. To them, it's like a shark fin, that they can, as long as they can see the shark fin, they're okay. But the minute the shark fin disappears, you don't know when the shark's gonna attack. So that can lead people to act in ways that are very counterintuitive. And we as a community and society have to learn to accept domestic violence isn't always going to be a rational relationship. It's not going to be something that maybe you may respond that way to. So first is removing the stigma. And the second is making sure that they understand the law and when they can make an arrest, when they should make an arrest, and what they should do from there, what orders they can enforce, what they can't. And then, of course, we want to make sure that we have the victim covered or the survivor. So we always teach our officers to make sure when you are responding to these circumstances, whether there's a PPO in place or not, you can explain to them what a PPO is, how they can get one. You want to make sure they have a safety plan should something happen in the future. And you want to point them in a direction where they can get some help in terms of a victim's advocate, if it be that person that can tell them where they can go to get some shelter, food if they need it, if they need financial assistance, all of those types of things, connecting them with resources, because our law enforcement is our first line of defense. They are the first person that arrives on scene. They are the first responders. So we try to equip them with as much information as we can to help them be both safe and successful. A lot of people have the connotation is that domestic violence still is a personal, private matter, but in fact, out of all the crimes, in my opinion, it affects the community more because studies show that women that are in domestic violence relationships will miss up to 3 months of work. That has an impact on taxes. They also need a lot of health care, and then the impact that it has on children in the home. So it's really a situation that then carries on to schools, and it impacts everybody. So the PPO is a very good first line of defense to help prevent that situation, give the person who's been battered in the domestic violence situation a chance to get away and have some safety and protection.
So the role of personal protection orders, protecting victims that have been involved in domestic violence, they're another tool in law enforcement's toolbox when possibly normal situations might prevent effecting an arrest. If there's a valid personal protection order that is in place, it gives law enforcement another opportunity to not only separate the individuals, but possibly take the offender into custody, preventing future harm of the victim. Their importance on protecting individuals is they give us a whole nother scope of rules, if you will, that individuals have to abide by. For example, without a personal protection order, there's nothing saying that an individual can't stand on the sidewalk 20 feet from your residence and yell obscenities to you. If there's a personal protection order in place and it says shall not be within 500 feet of a certain individual or a residence, you now have a court order that prevents that behavior. And if someone violates that, then we have a tool in place that we can take action with. The same thing with telecommunications, different harassments that typically would not be a violation of criminal law, but because there is a personal protection order in place prohibiting that conduct, it allows us to take enforcement action where we normally wouldn't be able to. So although they shouldn't be taken lightly and they shouldn't be abused, they are a very important tool that assists law enforcement.
Each tribal court in Michigan is very distinct. All 12 tribal federally recognized tribal nations have their own form of government. They have their own tribal codes, tribal courts. And so for each one of those, it's important to know what those processes or the laws are. But essentially, when you have individuals who are requesting PPOs, the process is very similar. Now, a lot of the tribal courts are online. There are different types of PPOs, whether it's a personal protection order, whether it's, they call them domestic relationships or a non-domestic relationship. So then you would either apply online and submit your paperwork, or you would go in and fill your paperwork out. And then the court clerk would be able to explain the process to you. There are ex parte PPOs, which means that the parties don't have to be in the courtroom, that the judge may sign a PPO order, but then there may be a court hearing after the fact. Or there may be a time where they require the parties to be at a court hearing. But again, those processes will be explained to the individual that's requesting the personal protection order.
When people feel that they need a personal protection order, when they come to the court, we try to make it as easy as possible. We have forms on our website. We do have at Little River a victim services department. So an advocate can help the person filling out the personal protection order with that process. And then you file it with the court. The court will look it over. We usually have a judge on site. If not, the court staff will call right away if it is an emergency. If we need more information than what is otherwise provided in the petition, if there's not a police report attached to it, we usually have a hearing and take testimony from the person requesting the personal protection order. Then at that point, the judge either decides if the requirements have been met and either signs it, or if they don't sign it immediately, we'll set it for a hearing. If it is signed, it is immediately taken over to the police department here, our Department of Public Safety, who does the actual service. They also will enter it into the Law Enforcement Information Network. And that's important because a lot of times if you're going off reservation, then you're going to need to have that protection.
Everybody is supposed to enforce the personal protection order, so when it's granted from a court, a tribal, state, or federal court, then the victim would actually carry, or the petitioner, they're known as both, the petitioner would carry the order signed by the judge from wherever they got it and allow other people to see that. Like if they call the police and they're in a different city or something, then they would be aware of the current personal protection order. However, they're all also in the system, a lien system, where they can actually look them up. But I would tell a client, carry the personal protection order, because you don't want anything to take longer. You want the police officer to see immediately, basically, if you have to call for help.
I think one of the best advantages that we have in handling these types of things internally is that the victims will receive services through the tribe. And those are going to be culturally sensitive. Those are going to be in ways that the person is familiar with. They are going to be with people that they are familiar with. We don't have the dockets that the state courts have. So we have the time to spend with those people. The services that are provided, there's more time to be spent with the survivors. Not only does it benefit survivors, but it's also going to benefit offenders, because we have the time and the resources to be able to really dial in what is the issue and how we can get the person help, victim-wise and offender-wise.
PPOs are the first line of defense against domestic violence situations. Obviously, PPOs can cover people that are not in domestic relationships. And when I say domestic relationships, I'm referring to statute allows for anyone that's in a dating relationship or a prior dating relationship, somebody who's a family member or somebody that's lived in the same household. That's a domestic relationship PPO. There's also PPOs that cover specifically sexual assault, as well as neighborhood disputes is what we would call them. They're PH case codes. So they're people that haven't had that domestic relationship but have some sort of dispute. In state court, when a PPO gets entered, it gets sent through the court clerk over to MSP, and MSP, Michigan State Police, enters it into the lien system, which means that it's accessible to all of our police officers if you should get pulled over or if it's been served. Part of our teaching is that you can serve the PPO in the patrol car. So if you go to a call and there's a PPO that, let's say person A tells you, I applied for a PPO, and the officer says, is it served? Or they can see in lien it's not served. They then have the ability to serve it. And all they have to do is either read it or have dispatch read it, and then there's a little card the next day that they file to say that it's been served. And then it's fully functional. We always tell officers, make sure you arrest on a PPO violation, and then you let your prosecutor know, because two things can happen. If we have an open criminal case, like a domestic violence case, we can file a motion to revoke the bond and have them incarcerated or sanctioned some way. Number two, we can cause to be filed a criminal complaint, which then can charge them with a felony or a misdemeanor, whether it be stalking, aggravated stalking, domestic violence, a whole slew of things that follow thereafter.
I would love to see a more synergistic relationship between the entities for a variety of reasons. One, we all stand for a common goal, right? Doesn't matter what uniform you're wearing. If you're a law enforcement officer, we're peace officers. And we represent everyone. Doesn't matter who you are, we represent you all. And with the tribe having an even bigger imprint or footprint in Grand Traverse County, it only makes sense, right? Let's work together. And in the past, I'm not sure that that has always been the philosophy. It's mine. I'd like to move forward with it. I hope we can. I'm optimistic because, again, it's a common goal. We're all in this to serve and protect our community, and our community is inclusive. It's not one particular group or another. It's everyone.
We need to be a team, basically. Everybody's in their job, police officers, no matter where they are, whatever city, state, tribe, federal, or advocates, even prosecutors and attorneys. Like, usually it's because you want to help someone. You're trying to help. So why not get to know other people that have the same goals as you and figure out how we can better help people?
We need to educate law enforcement, we need to educate the judiciary, we need to educate attorneys and the public in general. It's helpful for victims to know that they can enforce their own rights under these tribal court protection orders. And it's helpful for perpetrators to know they can't get away with it just because someone steps off the reservation.